Thank you very much. I am very happy to be here. Talk a little bit about the ethics of tax interpretation. Does this advance it? Yes. In particular, the paper that I've written is organized along five points. I start with the moral obligation to obey law in general, and I conclude that there is a prima facie obligation to obey reasonably just laws in reasonably just societies. I then have a discussion of the hierarchy of the moral saliencies of particular laws. Say some laws require cooperation, some laws require compliance, other laws can be justifiably evaded. I then ask, what does compliance mean? Because tax law, I believe, is in that middle ground of compliance, and I argue that that depends upon your interpretive technique that you're using for the law in question. I then make an argument that based on the role of professional conduct as put forth by the American Bar Association, lawyers play two roles. One is they're advocates, that they also are advisors. And I argue that the ethics depends upon the role you're playing. And then the paper closes with a couple of examples, one of which is fairly simple because this article is going to appear in the Journal of Business Ethics, so it's not going to be a bunch of tax specialists reading it. So I wanted something that was fairly simple, and then extrapolate that out to a more complicated price transfer, like the double Irish Dutch sandwich type of a setting. With regard to political obligation, the paper starts with a discussion of the Socratic dialogues. Socrates has been condemned for corrupting the youth of Athens. Crito gives him an opportunity to escape, and he decides to drink Socrates decides to drink the fatal hemlock, and he gives 4 reasons as to why. One, he says, I've lived in Athens for a long time. That implies consent. Secondly, I've received benefits from the society. Therefore, I have an ethical obligation of gratitude. Third, my fellow citizens in Athens have been obeying the law. So out of a reciprocity notion of fairness, I ought to obey the law. And then anticipating real utilitarianism, he also makes an argument that if no one obeys the law, that Athens will fail. Turns out that legal philosophers and political philosophers have been debating those 4 reasons that Socrates articulated for the last 2,000 years, and no consensus has emerged. Whether any of those principles are beyond philosophical attack, there are political anarchists as well as philosophical anarchists that would challenge that idea. But in my paper, I'm not going to resolve that 2,000-year debate, but rather what I do is I choose on a pragmatic ground to assume that there is, with regard to most tax laws, there's a prima facie obligation to cooperate or to at least comply with the reasonably just laws promulgated in reasonably just states, and then I move on. So I have to start with a premise that's not perfectly defended, but it's a proposition that there is a moral obligation to obey law. Now, I have this hierarchy of law where I suggest that some things require cooperation. If you have a law that directly implicates human health, safety, and dignity, then I believe that simply living to the letter of the law or complying with the law is not sufficient. You have to cooperate and go beyond the law. So if you have a health and safety regulation that's inadequate to protect your workers, then hopefully the advisor as well as the executive that's making the decision will go beyond the law. So the law points to an important topic but doesn't provide the barometer. Similarly, with regard to civil disobedience, you go back to Antigone and she sprinkles dust on her brother Polynices, and Creon puts her on trial, and there's a debate upon whether or not you should follow the natural order of the cosmos or you should follow Creon's decree, and we have a debate starting with natural law 2,500 years ago. Most civil disobedience people are held up as heroes, including Gandhi and Martin Luther King Jr. and Harriet Tubman, and you can go on and on. And so there is a role for evasion. But I argue that tax should not be evaded, and it also does not require cooperation. So you don't have to pay more tax than is required, but you also have to avoid evasion. But what you need to do is to comply. Now, what does comply mean? The comply means it has something to do with how you interpret the regulation. And as Saul points out, law is an inadequate vessel of meaning, so it winds up being vague, it winds up being ambiguous, it has gaps, it can be conflicted. When you have all those things, we as lawyers know that we need to interpret. Now, when you interpret, you can choose between a plain meaning or a literal approach to the language, or alternatively, it could be a more purposeful interpretation of language. There's a full panoply of interpretive tools that include due deference to literal language, but also requires an application of constructive maxims, prior interpretations, and the underlying purpose and legislative intent. So there's a choice between approaches to statutory interpretation. Now, which of those two approaches is the appropriate one depends upon your role that you're playing as a lawyer. At least that's the argument in the paper. There are two different roles. One is advocacy and one is advising. In advocacy, you're required to be zealous, which means that you, as a lawyer, you're ethically required, morally required, to make the argument that will advance the interests of your client. So if that means plain meaning, you go with plain meaning. And if plain meaning has ambiguity in it, you argue the plain meaning ambiguity in a way that helps your client. Similarly, if it's more useful for you to go over to the full panoply of legislative, of interpretive techniques, then you do that. But when you're an advocate, you are zealous in your position that you're taking. Now, that can be just because there's an advocate on the other side, and hopefully there's a judge or jury, appellate court, whatever it might be, in the middle that's trying to figure out what's the best argument. But you choose your arguments based on, you don't suborn perjury, but beyond that, you're making an extraneous advocacy argument that reasons backwards. Your client wins, and you give a reason, rationale why. Now, the alternative is advising. And according to the model rules of professional conduct promulgated by the American Bar Association, lawyers are also advisors. Now, when they're advisors, for example, taking a tax position initially, what the rules say is that you're supposed to follow not just the letter of the law, but rather you're supposed to reflect upon the moral, economic, social, and political factors that impinge upon the law or that interact with the law. So the view on an advisor is more of one that I'm calling the ideal judge view. What would be the definitive interpretation of this law if you were an ideal judge rather than a practical advocate? And I argued in the paper that when you're doing tax advising, that's the role that you should be taking rather than the role of the advocate. I then illustrate that with a couple of case studies. The first case study has to do with Louisiana state sales tax. It turns out that in Louisiana, if you buy a personal property, you pay a 10% sales tax. If you buy it out of state in Texas, Texas is 3%, which is right next door to Louisiana. You bring the property over into Louisiana, you have to pay a use tax, which is the difference between the 10 and the 3%. Okay, a fellow about 5 years ago buys a recreational vehicle in Hammond, Louisiana. It costs $350,000 for this vehicle. That's a $35,000 tax. He doesn't want to pay his tax. So what he winds up doing is he forms a limited liability company up in the state of Montana. Montana doesn't have a sales tax. He registers the vehicle there. He's never been to Montana. The vehicle's never been to Montana. He drives the vehicle in Louisiana, and he bought it in Louisiana. But he doesn't pay either a sales tax or a use tax. Now, how does he get away with that? Well, when you read the Louisiana statute, the statute says that you pay sales tax at the time of purchase, but with regard to vehicles, you pay it upon registration. He reads that as upon registration in Louisiana. I would say that's a gap, because you could read it as upon registration, first registration in any state. But he chooses the advocacy position that until he registers the vehicle in Louisiana, he shouldn't have to pay a tax. At any rate, the taxing authority winds up charges them with tax fraud. The administrative law judge fines for the taxing authority. It goes up to an appellate court and ultimately the Supreme Court of Louisiana. They fine for the taxpayer. Apparently what happened was that the taxing authority should have charged the LLC as well as the man in his individual capacity. In addition, they should have brought up the various GARs that were available for them in Louisiana. They could have gone to form to substance. They could have gone to economic purpose doctrine. In fact, when they asked the man, why did you do this, he readily admitted, I did it to avoid taxes. Well, seeing as how the Supreme Court has got a whole body of GARs in the United States, and we've recently codified the economic substance doctrine, it seems like he could very well have lost, but he wound up winning. Unfortunately, it set a precedent, winds up generating a cottage industry for people that wind up buying Louisiana license tag, Montana license tags. Some states have cracked down on it, have revised their codes. In Arizona and in California, if your neighbor's got a Montana tag, there's a hotline you can call and inform upon them. And in Massachusetts and Colorado, they've gotten criminal convictions. The Louisiana dissent, and some people in Louisiana have said we got to reform our law, but so far it has not been reformed. Now, I use that example as a fairly simple one, particularly for people in this audience, but as far as just trying to make it clear as to what we're talking about in terms of interpretation, because there was more than one way that you could have interpreted that statute. And what the person wound up doing was they interpreted the statute in a way that advanced their own best interest, which I think is appropriate if you're in an advocacy role, but inappropriate if you're in an advising role. Now, does that same exact principle apply throughout global profit shifting? It does. It's just more complicated, but it still ultimately comes down to the question of interpretation. I'm still perplexed as to why courts are not more aggressive in their use of GARs. I understand that there's been co-opting of all sorts of enablers, but it strikes me as courts have been co-opted too. I know, in reading Richard Murphy's book, Joy of Tax, he has this nice quote from a Judge Carnes in the 19th century that says that, the judge says, I don't know whether there is such a thing as an equitable interpretation, but I do know one thing, it doesn't apply in tax. And you get these literal interpretations from the courts that really need to be more pragmatic. This paper is not really criticizing the courts. I've done that in a different paper. This paper is really talking about the ethical obligation of the corporate executive as well as the ethics of the lawyer. Thank you.